Our next speaker is Howard Nations. He has been at the forefront of civil and personal injury litigation for 45 years and has built a national practice focused on mass tort pharmaceuticals, individual catastrophic injuries, and complex business litigation. He has 3 trial board certifications and has tried countless cases involving real estate fraud, domestic relations, among others. He also represented the accused in more than 300 pro bono criminal cases. That's a tribute in and of itself. As a pioneer in courtroom technology, he was the first attorney to have computer-generated liability and medical animations admitted into evidence in trial. As a leader in education, Howard co-founded the American Association for Justice National College of Advocacy and has taught advocacy-related courses in law schools for 35 years. As one of the most sought-after educators in the legal profession, he is widely published and has lectured to lawyers in every one of the 50 states. He also pioneered the use of forensic, psychological, and neuro-linguistic, I actually got that right, neuro-linguistic, now I've lost my place. That'll teach me to deviate from what Rhea wrote me to write or say. He also pioneered the use of forensic, psychological, and neuro-linguistic principles to persuade judges and jurors in trial. In 2012, Howard Nations was inducted into the Trial Lawyer Hall of Fame, and in 2014, he was bestowed the Lifetime Achievement Award by the American Association of Justice. As a leader of the trial bar, Howard Nations is past president of the National Trial Lawyers, Texas Trial Lawyers, Southern Trial Lawyers Association, and the Melvin Belli Society and Alethea Institute, and served 5 years on AAJ's executive committee. He has been honored with the Belli Society's Mel Award, the Mass Torts Made Perfect's Clarence Darrow Award, the Southern Trial Lawyers Association Warhorse Award, AAJ's Heavy Lifting Award, Southern Trial Lawyers Association Tommy Malone Great American Eagle Award, the State Bar of Texas Gene Cavins Award, the Southern Trial Lawyers Association Lighthouse Award, and the Association of Interstate Trucking Lawyers of America's Man in the Arena Award. What more can I say? Please give a warm welcome to Howard Nations.
That's all the time we have. Thank you very much. First time I lectured in these hallowed halls of Harvard back in the late 70s. A professor here is a friend of mine. We were knocking them out of the park back then in those days in personal injury litigation in Texas. And a professor asked me, he said, you know, you folks in Texas must have the most generous jurors in the world. They keep awarding all these big 7-figure verdicts. And I said, well, our folks are generous. They accurately reflect our populace. But they're also, I want you to know, there's some tough jurors in Texas too. And I told him about a voir dire examination I'd just seen where a hyperkinetic prosecutor, voir diring on the death penalty, asked this elderly school teacher, nice lady, said, now you, ma'am, if you're chosen as a juror in this case, and if the state of Texas proves beyond a reasonable doubt the horrible, horrific, and horrendous conduct of this defendant, can you return a judgment of death by lethal injection? And she thought about that for a moment, and she said, you do that up in Huntsville, don't you? He said, yes, ma'am, we do. And she said, well, you know, I can't do it during the week, but I'd sure be glad to come up and do it on the weekends. So we have some, we got some pretty tough, I'm looking for her on punitive damages cases against these pharmaceutical companies is what I'm looking for. Okay, let me tell you a little, the absolute key to what's going on in the wonderful world of psychology. So, strangely enough, it comes from a man who received the Nobel Prize in economics for this book, Daniel Kahneman, Nobel Prize in economics. It is the most, this thing is, if my Bible were as dog-eared as this, I'd be probably a lot better shape eventually. But this is just the word on so much research, so much experimental psychology that completely has to do with persuasion. And so a lot of what I'm going to talk about has to do with things that I've been teaching for years, and Kahneman pulled it together better than anybody ever, and it's incredible to know. Let's talk about the predicate we're looking at today. When we walk into a courtroom today, a lot of jurors see this. What it does is it raises expectation. It raises expectation that they're going to hear more than just testimony from a witness stand. They expect to see things, especially when they see those little monitors in the jury box. And they expect us to inform them. Unfortunately, they also expect us to entertain them. David Kelly is one of our, is present in every courtroom. Because what he's done is created these impressions that when jurors come into the courtroom, they've seen it. They've seen everything David Kelly wrote, going back to L.A. Law, Ally McBeal, and Boston Legal. And boy, isn't trial fun? I mean, seriously. You get to listen to these 90-second closing arguments that turn murderers loose on society and bring in multi-million-dollar verdicts. So they come in with a high expectation that we're going to inform them and entertain them. And what do they get? What's the one word most frequently used to describe jury service by actual jurors? Hello, it's not rocket science. We bore them to absolute tears. So I want to try to tell you a little bit about cutting to the chase and some things that I've learned, especially from Kahneman. Kahneman just verified a lot of experience that I've had and a lot of things that I've heard from a lot of great trial lawyers over the years. Storytelling. Jerry Spence was the first guy I saw that really nailed it, as is so often true. Jerry said, it's all about storytelling. I think he published that in an article. It's all about storytelling, and that's the first time I've ever seen it. The lawyer with the best story wins. Now, what you learn from Kahneman is that we have what I've been calling for years conscious and unconscious mind appeals. He calls it System 1 and System 2, slow thinking and fast thinking. And when we're persuading, we have to think in terms of the two systems that we're persuading in the brain. The first system I call the conscious mind. The conscious mind is the part of the mind that actually calculates things. It's things that we have to ponder, have to think about. The unconscious mind is the part that automatically takes in everything. When we deliver a persuasive message, the words we use, the verbal communication, constitute only 8% of the persuasive process. That's pretty amazing. That's not to say words are not important. Words are extremely important. We spend a lot of time with focus groups figuring out the exact words we need to be using. But it's only 8% of the delivery of your message. The vocal tone is 37% of the persuasive process. How do you sound? The use of, you just commented on silence. Silence is a very powerful tool. If you're standing in front of a jury and you've got a juror that's just not paying attention, or two or three, just stand there for a moment. And then they'll look up and say, what did I miss? They'll look up to see what's going on. It's a way to get people back, get their attention back. But vocal quality is extremely important, 37% of the persuasive process. What does that leave? 55% of the persuasive process is nonverbal communication, because nonverbal communication is the part of the communication that is processed in the unconscious mind. It's what Kahneman calls fast thinking. We don't have to process it, and I'll talk to you a little bit about how we can get into the unconscious mind directly as part of our persuasive process. The trial story bias. Here's the important thing about trial stories. You don't have the only one in the courtroom. Each juror imposes their own narrative on the case. It's called the trial story bias. They impose their own, they create their own trial story. And here's the decision-making process. During primacy portion of the trial, each juror forms their own model of the case, their own trial story. Primacy is the acquisition of information, which we'll talk about in a minute. It's everything that happens up to voir dire examination, the voir dire and the opening statement. That's the primacy portion of the trial. And they're forming, at the end of the primacy portion of the trial, they have their own idea of what the case is about. That old thing about at the end of the opening statement, jurors have made up their mind on the decision in the case, that's absolutely wrong. That's not what the study said in the first place, and if it had, it would have been completely wrong. What is right is that each juror, by the end of your first witness, has formed in their own mind their idea of what the case is about, and it's their version of the trial story. So that's the important part of your that's an important part of your trial story. Now, the decision-making process is orientation. Excuse me, I've got a little sore throat this morning. Orientation is what happens from the time, as Percy Foreman used to say, from the time they look through that little glass in the courtroom door when they're out there as a jury panel member and they're standing to see what's going on. From the time they walk in the courtroom, orientation begins. They start looking around to see what's happening. Now, Percy Foreman was my very dear friend and mentor and a hero, and unbelievable trial lawyer. But I watched Percy. I went over one time, he said, come over, just sit there and watch. And I watched him, and he said, look at me and look at the prosecutor when the jury panel comes in. So the sheriff starts bringing the panel in, and Percy's back here talking to the court clerk. How are you? Good to see you. Then he walks over and he shakes hands with the court reporter. This is what the jury sees, the panel sees as they're walking in. He walks over to the sheriff's bringing the people in. He walks over here, he stands here, and his message is, his nonverbal communication is, good morning, welcome to my courtroom. This is my clerk, this is my court reporter. My judge will be here in just a minute. And the 12 of you who are privileged will get to be my jurors. He owned the courtroom non-verbally. Now, I looked over at the prosecutor, and the prosecutor was literally like this. And what was his non-verbal? Oh my God, they're here already? You know? So, first impression. You only get one chance to make a first impression, and that's the important one. All right, so orientation. They have conflict. They see something different than what they expected when they got there. So conflict comes up, and then they start out of conflict. You hear the prosecutor side, you hear the defense side. Out of the conflict emerges. They start emerging their own version of what's going on. And then here's the important part. They start, once they get that trial story in their mind, they start looking for evidence that will reinforce it. So the role of the trial story is a filter for the evidence. They look at things in terms of their view of the case. Now, they filter it through their view of the case. Now, the gaps, when you leave gaps in the evidence, gaps are filled by what? By their own biases. But so keep that in mind. Bias comes into play very heavily in the absence of evidence. They got to do something. They got to make a decision. So just be sure that you're covering everything you need to cover. Be sure you're not leaving gaps in the evidence. How do you do that? You test your case before focus groups, and you listen to them deliberate, and you learn from them where your gaps are in your evidence. Now, their trial stories are based upon their value beliefs and on their own personal life experiences. So you have to pay very close attention to the life experiences. So the more data you can get on the life experiences of your jurors, the better off you are, the better chance you give yourself. The juror's trial story, here's where they use it. They use it to perceive information in the first place. They filter. Then they store. They store it in their memory, in the short-term memory, and then most importantly, when they get in the jury room and they have to retrieve information, they retrieve in terms of their own trial story. They search their own mind for their own trial story, and that makes it extremely important. So you need to argue, direct, cross, close, and persuade in terms of your trial story. Now, once each juror forms the trial story, they'll seek evidence that supports it. They form beliefs during primacy, and so what you should try to do, you need to try to tap into the model. First, you want them to accept your trial story as their own, but you want to tap into the model of the leaders of the jury. We always watch jurors during the breaks. I don't do it, but I have people that are watching the jurors during the breaks, and you watch how they congregate. You see these same little groups of 3 or 4 hanging out together every time they have a break or when they go to lunch. And in that group of 3 or 4, there's that one person that's doing 90% of the talking. It's not going to be any different in the jury room. So you try to identify who your jury leaders are, obviously. And we can all tell horror stories about how wrong we've been there, but even more horror stories about, then you try to identify among those leaders who's on your side, who's going with you. And that's where the horror stories really come in. The jurors' options, they can form their own trial story. And I've got plaintiff and defendant in here. I didn't change the slideshow. I usually give this speech to plaintiff's lawyers, but so they can adopt your trial story, or they can adopt the prosecution's trial story. Now, it's been my experience that you have a much better chance of a jury adopting your trial story if you have one. It took me a long time to figure that out, but I can say it. It's axiomatic now. So you want to have a very clear trial story. You want to know exactly what your trial story is. So you want to get them to discover it as their, but you not only want them to adopt your trial story, but you want to adopt it as their own. And you want to adopt it using the Zeigarnik effect. The Zeigarnik effect says that people will embrace that which they discover for themselves and hold on to it longer than that which they're spoon-fed. So it's better. I don't stand up if I'm trying to, I used to try a lot of brain injury cases, and you don't stand up on the jury on a brain injury case on voir dire and say, this is a case of permanent, irreversible brain damage. You start out with, this is a case involves a head injury. And then as you go along, you let them discover how serious it is. And I never use the term permanent irreversible brain injury until after the doctor's already used it. So I let them discover. You want them to think, okay, wow, this is serious. Oh, wow, this is very serious. Then as it goes along, this is even more serious. And wow, this is irreversible brain damage. Let them discover it for themselves. Let them discover their own trial story, but you need to feed it to them in such a way that you do. So we know that we all love stories. Information packaged and presented as a story has a strong positive influence on the decision-making process, no doubt about it. If you put together a good story, then everybody is going to resonate to it. Storytelling elicits a strong availability bias, which I'm going to mention in just a moment, by spotlighting, framing, and presenting evidence. The whole idea is to make it memorable. Now, there's 3 parts to a trial story. It's like any other story. There's a beginning, a middle, and an end. The way I found, I've never done any better than what they taught me in the military. The military method of teaching is you tell them what you're going to tell them, then you tell them what you told them. It's just that simple. You tell them what you're going to tell them in voir dire and opening statement. You tell them during the evidence and during cross-examination, during the evidentiary portion. You tell them what you told them in closing argument. That's the presentation of a trial story, and like I said, I haven't figured out how to improve on the military. Now, putting together your trial story, and this is something that may be helpful to you. Putting together your trial story, if you look at each person that has evidence to offer and consider what their statement is, but tell yourself the story, repeat their story in the first person. I'm talking about when you're preparing your case, when you're putting together your trial story. You put their story, so you've got a witness, you got an eyewitness, and you have a statement from the eyewitness. And the eyewitness was standing at this location and saw this person driving at this distance. The ideal thing to do is to go to that location and repeat the witness's trial story in the first person, standing where they were at the time, saying what they say they saw. It really gives you an identification with, you will see things immediately. Well, wait a minute, that's not possible. So tell it in the first person, prepare it in the first person. We prepare every statement, every witness statement, we prepare it in the first person before we put our trial story together. The next thing is you can look at it from what we call the helicopter view. When you put them all together, your stories together, then you can look at it from the narrator view, and you can narrate the trial story as if you're looking at it, looking down on it from a helicopter, and you're telling things as a narrator. But you want to tell your story, and this goes back, you create it in the first person, and then here's the important thing, and trust me on this, Kahneman simply verified it, but the psychologists have known it for years. If you want to communicate directly with the unconscious mind, which is where your decision making takes place, the conscious mind comes into play when the unconscious mind has something that needs to be clarified. If you just penetrate the unconscious mind, it's there. You're there. You're in the brain. You're stored. The conscious mind doesn't come into play unless it needs ratification, needs something else. Here's why you tell the story in the present tense. The unconscious mind, which is where decision making is initially made, does not resonate in the past. It doesn't program in the past. It doesn't process past events. It doesn't process future events. The unconscious mind processes only in the present tense. So if you want your story to resonate, you have to tell your story in the present tense. And then you're communicating directly with the unconscious mind. So you have an ongoing story. Then you do the same thing for your opponent's story. And look at your opponent's story. Look at the prosecution story. Go to the spot where their witnesses were and see what they saw, and try to tell their story in the present tense, and see. You'll get a different view on things. Storytelling in trial, you have to maintain consistency, and that is between your verbal, nonverbal, and vocal communication. Because if you're telling story, if you're using words that talk about this is my friend and client, but then your nonverbal communication during the breaks, during lunch hour, you're completely ignoring him. You have nothing to do with him. He's just your meal ticket. Your nonverbal communication says, I don't have anything to do with this guy. The verbal communication is saying, this is my friend. I have the privilege of representing my dear friend. Whatever. What's wrong with that? If there's inconsistency between the verbal and the nonverbal, who wins? The nonverbal will prevail every time. So what have you done? You've made yourself a liar. Then your verbal communication is a lie. So you have to maintain consistency between your nonverbal and verbal communication. I'm going to flip through this because this is the this is the story we use to tell the to teach to teach storytelling, and also to teach anchoring. This is the greatest class action that was never filed, which was the Titanic. Can you imagine that? It's owned by the richest man in the world, J. Pierpont Morgan, and they were racing across the ocean trying to set a new record, and he also killed several of the richest people in the world. Okay, so your main characters, I'm going to go through this just for 1 second just to show you something. Your main characters are the designer, the owner, the designer, and Ismay is a designer, and then Thomas Beach was a young boy that was killed on it. What we do, we focus on the themes, and in order to get the theme, there's several things you're looking at here. We use a technique that was taught to me by actually taught here when we were doing a college here, by a couple of actors. To really get your story pinned down, you try to put it into a 10-word telegram. Try to write, just every word has to be meaningful. And then you put down your 10-word telegram, and then you go back and say, is there a better word than that? Is there a better word than that? Is there a better word than that? Let me tell you where else you use that. Rhetorical questions are powerful. And you do the same thing with rhetorical questions. You write your rhetorical question, and then you go back, is there a stronger word than that? Is there a stronger? Let me show you what I'm talking about. Now, you also have language of the case. In every case has its own language. It has its own words. It has its own terms that may have particular meaning, or it has the potential to have. So to make sure we're on the same page with everybody, with jurors, we test the language of the case with focus groups. And we'll present a case to a focus group in very simple, clean language, and clean meaning no persuasion, just pure, simple, white language, and with no persuasion involved. No color to the language whatsoever. And then we'll listen to how they talk about it. We'll listen to what words they use to describe it. And we'll let them go into deliberation, and we film it. And then we watch them while they're deliberating. And we pick up what is the language of this case? How do jurors talk about this particular case? And then you have catchphrases that you can develop for each individual, for your individual cases. So Ismay is the owner of the he's the owner of the Titanic, and this is what actually happened. The designer had designed it with all the lifeboats in place, with 1,400 lifeboats. He had all the lifeboats enough to handle all the passengers. Then he had a meeting in London with Ismay, who was the owner. And Ismay had said, I need more luxury suites. I'm getting people like John Jacob Astor on this trip, which he was. And he said, I need more luxury suites. And so the designer says, I can't do it. There's no way to do it. And he said, well, find a way. So he said, I'm going to be back in here this weekend. I want to see it. So the designer has to go back in, and when Ismay comes in, he says, there's only one way to do it. You can put them up here, but you got to take out the lifeboats. And if you put in luxury suites, you will not have the lifeboats. Is this the greatest lawsuit never brought? I've gone back, checked the statute of limitations in the North Atlantic. And so he says, okay, take out the lifeboats. That actually happened, okay? And then to top it off, you couldn't write a better script. Ismay's on the ship, and the designer's on the ship when it goes down. The designer goes down with the ship. Ismay gets in one of the lifeboats, and he would have been available for the trial. Wow. So anyway, 10-word telegram. Ismay chooses profits over safety, suites over lifeboats, dooms passengers, and then the last two words are usually it's the altar call. It's a call to action. So what that does is it forces you to encapsulate your theme and what your story is all about. This one includes his positive choices. It has a standard theme. It's particularized to the case, and it's memorable. It has to be memorable. So I'm going to go through this. So it's the altar call. The altar call is action. Punish him. Balance the scales. You empower with rhetorical devices. Rhetorical tools of structure. One of the most powerful tools is the rhetorical question. And so, ladies and gentlemen, who is going to correct the grave injustice that's been visited upon this fine family? by the outrageous conduct of this defendant? If not you, who? And if not now, when? See, rhetorical questions where the answer, they know what the answer is, but they're formulating the answer in their own mind. So that's powerful stuff. Now let's talk. Doug wanted me to talk to you a little bit about anchoring, because we use this also to talk about anchoring. Anchoring is powerful stuff, and it is so powerful that Kahneman, in this book on Persuasion, does an entire chapter just on anchoring. Okay? Anchoring, first of all, you utilize your courtroom space, and you anchor your locations. And one of the things that we learn from the actors who work with us when we teach a college here every year, and one of the things we learn from the actors is you always have a purpose for every movement you make. You know, this is not how you do a closing argument, looking down at the floor and with your hands behind your back. You have a purpose. When you move in the courtroom, you're moving from this juror to this juror to this juror. And be sure you cover them all, but don't move from this juror to this juror to this juror to this juror. Oh, I'm next? Yeah, okay, hi, yeah. You have a purpose. There's a purpose for movement. So anchoring in a nutshell is this. Let's see if I've got a slide on it. Okay, so you have anchoring like this. Physical location. And during the course, let's say you're talking about a mental anguish, physical pain, general damages. And so you come to, when you talk to it, you come to this board, you've got this chart up here, and so when you examine a doctor about that, you always come to the same location. You talk about, all right, doctor, let's talk about the physical pain involved in this, and so forth. So then you're using the same graphics, you're using the same words, using the same vocal tone, and then you never question about anything else from this location. This is strictly your general damages location. You want to talk about liability, you go to a different location in the courtroom. You want to talk about a defective design, you go to a location and you use that there. But the same vocal tone, same verbal tone, and the same substantive evidence. Now, what does Kahneman say? And I'm going to tell you one that was pretty shocking, actually, about the other part of anchoring. Here's what Kahneman says. Anchoring can be measured, and it is an impressively large effect. Now, this is a guy who got the Nobel Prize for this, so you might want to listen to him. Anchoring can be measured, and it is an impressively large effect. Now, let me tell you about numbers. This is a test that Kahneman did. They did with 15. They had with German jurors who had at least 15 years on the bench. They read a description of a woman who shoplifted. That's all. They read the event. Then they rolled a dice. They rolled a dice, just one at a time. The judges did this independently. They would roll the dice. The die was always set to come out it was loaded to land on either 3 or 9. That's the only 2 numbers could come up. They'd roll the dice one time, and then they'd either get 3 or 9. The dice stopped. Then when the dice would stop rolling, they would say what their sentence would be, and they sentenced to more or less than the number on the dice. Okay? The rolling of the dice has absolutely nothing whatsoever to do with a fair and just punishment, obviously. But then after they decided what their sentence would be, they specified what the sentence would be. The average was those who rolled a 9 sentenced this woman to 8 months. Those who rolled a 3 sentenced the woman to 5 months. That is the anchoring effect of numbers. My point is, be extremely careful what numbers you toss around in the courtroom when you're in the sentencing phase. If you ask for a smaller number, if you're talking about numbers, be sure you've got an anchor. You want to anchor it to a reasonable number. The minimum dictates, the decision. Let's say the jury is punishing the decision of the amount of time that should be given in this case is completely up to you. But the minimum dictates of justice require that it be absolutely no more than whatever. Pick a number. Pick a low number. It has an effect. The way we use it in personal injury litigation is if I can get a juror questionnaire, I'll have a question on a juror questionnaire that they fill out before the voir dire examination. And the question will be, if the evidence supports it, I can award $5 million in this case. Answer yes or no, and if you answer no, explain why. Well, if they explain why, that'll pull out the tort reformers and help you identify them and use it as grounds to strike them. But what you've done is you've anchored them to that number. We do a trial here every year. We do an advanced college that I started here back in '88, and we do a trial. This is with very experienced lawyers, and we bring in Harvard students as our jurors. And so then we put them in. We try the case. I was a judge. We try the case. We put them in. We let them deliberate, and we film them, and we bring them back out and. They spend almost no time at all talking about damages, although that was the big issue in the case. And they returned an award of $3 million. And so then I brought them back out and debriefed them. And you should have seen it. You should have seen their expressions when they realized that they had been filmed the whole time. Everybody's thinking, okay, did I tell any lawyer jokes? Did I say anything? So the answer to the question was $3 million. So I asked this question. I said, suppose, because the plaintiffs had asked for the lawyers that argued the case had asked for $6 million. And I said, okay, what would have been the award? Each one of you right now, write down your award of what you would have awarded if they had asked for $12 million. Everyone said $6 million. They just assume that they're asking for twice what they want. So there's an effect to numbers. Be extremely careful about numbers that you're talking about in the courtroom. Okay, I want to talk about the availability bias. This is an extremely important thing. I call it the spotlight theory. The jury will focus in deliberation where the spotlight was placed during trial and summation. You get to choose where you want to place the spotlight. Be careful about putting too much information on about your own plaintiff, or your own defendant rather, because that's where the person they get the most criticism. The person that has the most evidence gets the most criticism. I want to show you how this works. The whole idea is focus. Now I'm going to put this up here. I want you to focus. Pick one card to focus on to see if I can get you to focus. This is spotlight. 3 seconds. Okay. Now, if I got you to focus in the right spot, your card should have disappeared. Okay. Now on the availability bias, what you're trying to do is you have to pick, and you test this again on in your focus groups. What is the evidence you really need to focus on? And you do this, you get to the point by, you take every bit of all your possible testimony, lay testimony, expert testimony, demonstrative evidence, and documentary evidence, and pick out what is the most important thing that I need to get the jury to focus on. Where does this piece of lay testimony fit into my trial story? And am I putting a lot of superfluous things in here that I don't need? Do you get in, make your point, get out? That's always been my theory of trying lawsuits. You get in, you make your point, you get out. I don't really have time. Just don't do that. So you test it with focus groups. Now, I'll get back to the reason that the consistency of your message is so important is because of trustworthiness. Now, I'm skipping around a little bit here because I'm short on time. A couple of things another psychological principles. Reactive attribution. And if you can put your defendant in this position in any way, it helps you. If you can show that the defendant, your client, was in a reactive mode, that they were not the person who caused the initial action, but they are reacting, then a jury has a tendency to forgive that. We all have a tendency to forgive people who are simply reacting. Maybe they didn't react properly, but it's not nearly as bad as purposive attribution. Purposive attribution, if you can show that someone else was acting on purpose, not willfully, but just on purpose. They decided, they chose to act that way. Purposive attribution, they'll actually, depending on how bad it was, they'll actually bring about punishment. So you play down the purposive actions of your defendant and stress the reactive attribution. The case right now of Susan Bland in Texas, in Waller County, she was reacting when the cop comes up and tells her get out of the car and all this sort of thing. She was in a reactive mode. All she did was she didn't put on her turn signal. Actually, the police officer was riding behind her, and so she's moving her car over she's changing lanes to let him go by. She changes lanes without putting her signal on, so he pulls her over. Simple situation, write a ticket, it's over. Give a warning, it's over. Instead, he's get out of the car. Now she's in a reactive mode. So if you had that case, if you're talking about, then if you prove that your person is reactive, you're in a much better position from a psychological viewpoint. Milton Erickson, the great psychologist who taught us the extreme importance of verbal, nonverbal, and vocal communication being a synthesis. And unfortunately, I don't have time to do this one, so I'll skip over it. All right, so one of the biggest studies done, there were 1,500 actual jurors who were debriefed. And after jury trials, they were debriefed by forensic psychologists, and they asked them a whole bunch of questions. And they had, one of the things that came out of it was, what do you think of the lawyers? And those people who liked the lawyers, what was your reason for liking the lawyers? What do you like best about the lawyers? And the three things that came out of it were trustworthiness, the things that make people like lawyers. Trustworthiness, competence, and dynamism. If you lose your trustworthiness, your client's in deep trouble. So don't over-try your case. I always tell people on the personal injury side, try the case you have, not the case you wish you had. And so be careful about over-trying your case, making statements you can't support. Don't ever make promises to a jury, obviously. And then your competence. The idea of, that's why I like the get in, make your point, and get out. Boring. They don't want to be bored. You spend a lot of time asking a lot of things that are making a lot of objections that have no real relevance to anything. They feel like that you're incompetent. They won't like the lawyer. And dynamism just simply means keeping them awake. Here's an anchor you want to create, is this anchor. You want the anchor to be, when the judge says, Mr. Nations, you may proceed, you want your name to be an anchor. When the judge says, Mr. Nations, you may proceed, the anchor is, okay, something's about to happen. Now I have to listen. Now I have to pay attention. The way you create that anchor is when the judge calls your name and says you may proceed, you make something happen. You don't ask the stupid, now did I understand the testimony you just gave to be? Yeah, that's what they said. We all heard it. That's not cross-examination. That's thinking of something while you're trying to think of something. Okay, the ancient principles of audiences are influenced by the way the message is structured and delivered. There's no question about this. This is part of your storytelling. How do you structure your message? If you look at the ancient orators, and you go back 2,000 years. And you look at the incredible trials of Cicero and Pericles. They all use the same rhetorical device. You could check Pericles, look at Sophocles, and of course the father of them all, Testicles. Now, all right, that's a test. I want to make sure you're paying attention. All right. But they all use the same rhetorical devices. Framing, the way a question is framed, can have an enormous impact on the answer. Let me give you a quick example. We had the Astrodome, where the Astros played baseball. The developers wanted to, they bought up a bunch of very, very cheap property downtown, and they were only going to get rich if we built a new baseball stadium. People, I had season tickets forever at the Astrodome, loved it. So they were trying to convince the county and the city and the sports authority to build a new baseball stadium. So they ran a test, and they questioned the citizens. And they asked the question, do you want to build a new baseball stadium downtown? The answer was 67% said no, 33% said hell no. Now, what did they do? There's a lesson here. They reframed the question. This is absolutely true. This is exactly what happened. They reframed the question. They made the question, would you prefer to have a new baseball stadium on the parking lot of the Astrodome or downtown? 67% said downtown, 1/3 said the parking lot at the Astrodome. We now have a $400 million baseball stadium downtown. Okay? That's the power of reframing. That's why these stupid political surveys are so inane, because you tell me what answer you want and let me write the question, I'll get your answer for you. So it's all about reframing. So think about how you're reframing your questions. Reframe your diluted messages into persuasive, pithy, and probative. Your message is, Susan was a highly skilled computer software designer with a PhD in computer sciences. That's your message, okay? When you dilute that message, she was a cheerleader in high school, made National Honor Society, and dated the captain of the football team. Take out all the superfluous stuff. I know you may be personalized. If it serves a purpose, like personalizing her or showing education or showing something valuable, fine. But cut through all the BS in your questioning and in your evidence. Your principle of sequencing. Use this in your order of proof as well. Think about how you're sequencing your testimony, and think, when you're putting on your case, think how extremely important the first witness is, because you have a primacy portion of your case too. The primacy portion of your case begins with, you have your opening statement, and you have your then you have all the cross-examination of prosecution witnesses, but then they're waiting to hear what you've got to say. Your first witness is your most important. So think about your order of proof and your order of presentation of evidence. Now, sequencing. Steve is envious, stubborn, critical, impulsive, industrious, and intelligent. On the other hand, Frank is intelligent, industrious, impulsive, critical, stubborn, and envious. Which one do you like best? You like Frank, because he's intelligent, he's industrious, he's impulsive, and he's exactly the same as Steve. It's just a question of how you sequenced it, you see. So think about sequencing. Sequencing is extremely important. And these are actual tests. I didn't write this stuff. These are actual tests, and the test results come out that everybody likes Frank better. Okay, so the power of metaphors. Now let me tell you about metaphors. If you want to communicate directly with the unconscious mind, you use metaphors. You need to create metaphors in your case that make a powerful point for you. There are few things in the English language that carry more weight or more power than metaphors. The reason is metaphors communicate directly with the unconscious mind. They do not have to be processed. So you want to get a metaphor in your case. you want to get analogies in your case. Analogies resonate. And again, the way to get them is you get a focus group, and you ask your focus group for what's an analogy. Quick example: I represented a child who had 9 defibrillations, and as a result of an overdose of digitalis. Had to be a 9-month-old child that had to be defibrillated 9 times. And so defibrillation, as Aristotle said, does not execute the required level of emotion. So I'm asking my doctor, I said, okay, tell me this, describe this in the present tense for me, tell me what goes on. Tell me about defibrillation. And so he says, well, you put a paddle here, you send an electric shock through the heart with sufficient force to what? Stop it from beating. The next signal from the brain comes down, starts the heart beating in normal pattern again. Now, Phil, answer this question. It's just like what? It's just like electrocution. Now, I'm arguing a case where a 9-month-old child was electrocuted 9 times with sufficient force to stop their heart from beating. A required level of emotion. I got the largest verdict ever obtained in the state. In fact, it had to be remitted because electrocuting a child is a hell of a lot different than defibrillating one. So words are important. Metaphors are important. Analogies are important. So think about how you can use those. And the other thing is you're using these word structures. These are the ones that I talk about: Cicero, Sophocles, Pericles, all of them use. Antithesis: let us never negotiate out of fear, but let us never fear to negotiate. Absence of evidence is not evidence of absence. The rule of 3. The rule of 3 is one of the most powerful rhetorical tools that you can use. We think in terms of 3s, we remember in terms of 3s, and the classic example of that was, as usual, comes from Churchill, who, and given one of those incredible, memorable speeches he gave in World War II on the radio to keep the British people fighting and to keep their spirit up, he said they were talking about the impending invasion of Britain, which was expected at any moment. He said, "We shall fight them on the beaches, we shall fight them in the streets, we shall fight them in our homes. We shall never, never, never surrender." He understands the use of the rule of 3. Parallel structures are a very good technique too. You will see 2 John Jones in this case. You do this in opening statement. We're going to bring you 2 John Jones. The one is the accused, the one is the actual person. And then when you come back to summation, as we said, we would show you 2 John Jones in this case. We did show you this John Jones and this John Jones, and it's a very powerful. It's a powerful tool. So, see if there's anything else. I'm about out of time. Oh, the echo effect. In your closing argument, if you want to see the echo effect is refrain, it's powerful. Read Martin Luther, read it, study Martin Luther King's use of repetition and echo. He uses the phrase, "I have a dream," 18 times in this, but notice how he uses it. It's not in a sentence, it's a refrain, and it is a powerful, powerful, powerful tool. One reason why we're still studying it today. Another thing is this one, word choices, the Gettysburg Address. The Gettysburg Address is only 270 words. 203 of those are 1 syllable. Churchill said, short words are best and old short words are the very best. By old, he means those that everybody understands their meaning. They've been around for a long time, but short words have punch, they have power. And study the Gettysburg Address. It's one of the most powerful, and it was given in about three or 4 minutes. I gave this speech one time, and it was a luncheon speech, and I went back. The judge was at the luncheon, and I went back and asked him that afternoon. He said, "How much time do you need for closing argument, Mr. Nations?" I said, "I need an hour, Your Honor." And he said, well, you know, Mr. Nations, the Gettysburg Address was given in 4 minutes. And we still remember it so well today. I said, yeah, Judge, but Abe Lincoln wasn't on a contingent fee. So, you know, so we get our quotes from prose, poetry, biblical. Song lyrics are some of the best. Country songs in Texas, there's a country song for everything. If there's not a country song that doesn't fit your case, write one. The song lyrics, my wife ran off with my best friend, and Lord, I miss him so. There's a song lyric for everything. Let me leave you with this. Leave you with my favorite quote from Shakespeare. The first thing we do, let's kill all the lawyers. That's my favorite quote because it is a great compliment to the trial bar. It's a great compliment to our profession by the Bard. Because those of us who actually read the Bard rather than the Cliff Notes in college, both of us, understand that these are words spoken by Dick the Butcher, who was a follower of Jack Cade, who was an anarchist seeking to overthrow the government. And what he was saying was, if you want to overthrow the government and you want to overthrow the established order in society, the first thing we have to do is kill all the lawyers. And it's true because we are the frontline defenders of democracy. And Lord, at a time when we never needed it more. So I'll ask you to do two things. First, always maintain your own personal pride of you personally as being a lawyer. I'm extremely proud to be a lawyer. I've been a lawyer for 49 years, and I am proud of every minute of it. And I'll be just as proud of the next 49. But the other thing is to maintain your pride in the profession, not just yourself, but in the profession, because we all are the frontline defenders of democracy. We all have a role to play, and together, be it us, be the prosecutors, be it the judges, be it the defense lawyers, maybe not the pharmaceutical defense lawyers, but the defense, we all have a very important role to play in this society. So maintain your own pride both in your individual self as a lawyer and in the profession, so that 1,000 years from now, at the beginning of the next millennium, the Hitlers of the world, the dictators, will still be saying, the first thing we do, let's kill all the lawyers. Thank you very much.